From Amsterdam, this is Bright Minds, the podcast from the John Adams Institute, a treasure trove of the best and the brightest of American thinking. I'm Jonathan Gruber, and this episode's guest is someone notorious.
Your extreme views are outrageous. I am calling for your resignation. I deplore your alien anti-American ideology. I am ashamed that you were ever appointed to your position, and especially ashamed that you are a woman.
The now legendary late Supreme Court Justice Ruth Bader Ginsburg, speaking here at the John Adams in 1999, back when her Supreme Court career was young. After all, she was still serving under the president who appointed her, Bill Clinton. He himself had only just been impeached by the House of Representatives and acquitted in the Senate. Sounds familiar, right? Ruth Bader Ginsburg sat down for an interview and waxed legal about things like the court's role with regard to impeachment, the importance of being born in the right place at the right time, and what the court does and, more importantly, does not do. And she may be notorious, but she also talks about how the Supreme Court is a nice place to work and how the justices, at least back then, all care about each other very much. I wonder if that's still the case. Finally, she takes a few questions from her extraordinarily well-informed audience. So, now, before a full crowd at the University of Amsterdam, this is the late Ruth Bader Ginsburg being interviewed by the Dutch legal scholar and journalist Mark Chauvin, back in 1999.
Thank you, Madam Justice. And if I may recall for the audience, you've come from quite a distance, daughter of immigrants, working your way through schools, an outstanding student career at the law schools of Harvard and Columbia University. And then you found yourself too much a Jewish woman, a Jewish lawyer, and a Jewish mother. 3 bridges too far to be hired by the legal profession in New York City. Yet, the adjacent state of New Jersey was wise enough, at least Rutgers University, to hire you. And later on you became an important member of the staff of Columbia Law School to become a federal court judge. And then in 1993, the current president of the United States was wise enough to propose you and let you become the second woman Supreme Court justice. Can you, for the audience, recall what surprised you most after this already impressive career and when you became one of the 9 pillars of legal wisdom in the United States?
The biggest and most pleasant surprise is, contrary to the brethren and a more recent book, the U.S. Supreme Court is the most collegial place I have ever worked. The 9 of us genuinely like each other. We are constantly in each other's company. We choose to have lunch together every day we sit. We genuinely care about each other's families. We celebrate such events as my granddaughter's 3rd birthday at the court. So beyond any law faculty, beyond the Court of Appeals where I worked, this is a truly collegial institution, and we, all of us, appreciate that institution is so much greater than the 9 of us as individuals.
So all this talk of political nominations is actually for the papers?
Of course, political views enter into a judge's selection by a president. One can think of no clearer example than President Eisenhower, who chose Earl Warren, a tough-on-crime prosecutor, governor of the state of California, supportive of evacuating the Japanese Americans, appointed Earl Warren to be Chief Justice of the United States Supreme Court. And yet history will recall Earl Warren as one of the bravest, boldest, liberal Chief Justices we ever had.
You've been talking about presidents taking the courage to name people they didn't want to hire and yet got. And you just mentioned Madison's fascinating compliment to the Supreme Court talking about an impenetrable bulwark against every assumption of power. Why actually did the American people put more faith in its partly non-elected judges than in its elected politicians? Might it stem from a distrust of democracy? Or what is it?
I'm not sure they knew exactly what they were doing in those days. Do you know that the Supreme Court originally was not considered a very important place to be? One justice, Rutledge, early on, resigned to become the chief judge of the state of South Carolina because he thought that that was more important, the state judiciary. Marshall had to be third, he was third or fourth, depending on whether you count Rutledge. He was not altogether sure that he wanted the job, but he took it, and he made that court the institution that it is. He saw the need to take 13 jealous colonies and forge them into one nation. And the people liked it. Commerce was better, as I think the EU is finding when there are not trade barriers. So the Constitution itself is kind of vague on whether the courts have this judicial review authority, but Marshall exercised it, and it worked.
If the Supreme Court has managed to become this most trustworthy authority for maintaining what you call the law in the United States, more so than the democratically elected Congress, why is this Supreme Court, in the very instance we're living at the moment, not good enough when it comes to judging the highest executive authority in the land? I mean, legislators considering hiring judicial gowns proves the point that there is a question mark.
Because on that question, the Constitution leaves no doubt. It says that the president will be impeached by the House and tried by the Senate. It gives no role to the court. It gives a role only to one person, and that's my boss. He is to preside. The Constitution says he will preside when the president has been impeached. But otherwise, the Constitution says for this special case, for the impeachment of the president for high crimes and misdemeanors, the prosecutor is the House of Representatives, and the judge and jury of the Senate, and they have the last word.
Yet you just gave two, in my ears, fine examples of the Supreme Court being very delicate and effective in dealing with president's matters.
But the Supreme Court did indeed say that it is out of the business of impeachment, that the Constitution gives that business. So we did consider the question and ruled on it, not in the current case, but in another instance.
Is it an ideal setup?
It's only the second time in the history of the United States. It's a long time it's 130 years since Congress exercised that kind of muscle over the executive. You know that the Chief Justice, who is currently presiding over this trial, wrote a book called Grand Inquests. He thought that it would be a never or hardly ever again after those two episodes. Whether he's right remains to be seen.
So next century we'll take it from here.
Yeah.
Can you tell us in practical terms how the Supreme Court stays clear of political pressures? You just mentioned a few examples of famous Supreme Court justices who stayed on till they were over 85. I sort of recall that some of them were aware of the political balance and that helped them stay on for a while. What's the reality of political pressure within the court?
I doubt that it affects a person's judgment when to leave. For example, Justice Brennan was urged by some of his friends to retire earlier so that his successor could be appointed by a Democratic president. He thought that he was doing a good job on the court, and he didn't want to leave it until his doctor told him it was time to go, and that's what he did, and it happened to be on a Republican president's watch. So I think people stay in this job as long as they think they can do it effectively.
Well, if I may take your personal example, you've been known in the United States for quite a while as an advocate of women's rights, of human rights. You were a liberal. Has it been an advantage or a handicap that you were a women's rights advocate?
Overall, a tremendous advantage. I had the great good fortune to be born at the right place and the right time. I contrast what my mother's chances were, what her mother's chances were. There had been no time in the history of the United States when a woman could aspire and achieve to do whatever her talents would enable her to do. Until now, there were so many closed doors. Well, you don't want me to talk long, but I will tell you one story. The United States still has juries. We use them in civil cases and criminal cases because the Constitution requires it. But in many states, including my home state, women were not put on juries. In my lifetime, one of the big set of cases that I advocated was to put women on juries as the same basis as men. The very last case I argued in the Supreme Court was on that subject in 1979. That was rather late. On the brief, the turning point brief in the sex discrimination area, I put the names of two women, one Pauli Murray, the other Dorothy Kenyon, who had fought all their lives to give women an equal chance, and particularly to put them on juries. They were too old to participate with me, but I knew I was standing on the shoulders of those great ladies. In the 70s, the country was ready. In the 50s, it wasn't.
You've been rather effective as an advocate of women's rights.
Yes.
The Supreme Court, under your wise hands, has explained the law in a favorable way for women's rights, contrary to tradition, as you've experienced yourself. These days, I read about your work that you favor a modest judiciary that's not writing the law all the time, not telling the executive how to legislate.
Yes.
Do you think you've seduced the Supreme Court to be more activist than you would like to be yourself?
I think in the cases where I was an advocate, the Supreme Court was just putting its stamp of approval on the side of a change that had already occurred in society. Some states move slower than others, but on the jury, it was never just go to the court alone. It was, you tried to get the states to change their laws, you tried to get the federal government to change its laws. All these things were working together. To take just one of many examples, in the 1970s, our military academies, West Point, Annapolis, they did not admit women. A lawsuit was started with very able plaintiffs. Congress, in the middle of the lawsuit, decided, gee, they're right. We should open the doors of the academy to women. So I'd say that our institutions are interdependent in that way, and there's always a dialogue going on between the courts and the legislative branch. But I cannot, obviously, as a member of a body of 9, just project my will and rule all the others. I have an expression I use sometimes. If I were queen, there would be this or that. But I'm not. I'm there with 8 others. And I much rather carry at least 4 other minds to make 5 and write small than write a grand dissent for 1.
If you were the queen, I'm pretty sure you would change the law concerning the death penalty in the United States. as you arrived in Amsterdam, you still had to give your opinion on a case concerning life and death. Is it at odds with human rights, as you've always advocated?
I can just tell you that this Constitution of ours twice refers to capital crimes, so it assumes that there is a death penalty. That's one hurdle to overcome. Another is to be part of a system where the people have strongly said they favor the death penalty. I think in our earlier conversation, I told you about California, where the Supreme Court of California said the death penalty is cruel and unusual under all circumstances and therefore is invalid. The good people of California put that issue on the ballot, and they voted overwhelmingly to amend their constitution to reinstate the death penalty. Well, that's just an example of the court, the people. How far in front of the people can a court be if it expects its judgments to prevail? Now, my spouse will confirm that the first time I was in this business, I was a judge for 13 years in a place that had no death penalty. The DC then had no death penalty. When I got to my new court, I found first the law was impossible. It was very, very dense. Nancy will back me up on that. It just to learn it. And the first night, the execution was at 3 a.m. I stayed up. I cried, and it was over. And I have to make a decision. Am I going to be part of this group and try to be an influence, or am I going to say, I will take myself out of it and therefore not be effective at all in the decisions that are made?
And do you every now and then come up with new arguments to try to convince the friends of your grandchildren?
We seldom are original in the Supreme Court. You know, we get these briefs from all sides and all friends. And I think I mentioned to you one recent decision. The defendant said, there's a choice that the jury didn't know about. That is, it wasn't the choice between putting me away for a term of years or killing me. There is in this state a sentence of life in prison with no possibility of parole. And the court said, yes, the jury should have been told that that was an option, because maybe they would not have administered the death penalty if they knew that this very, very dangerous man would never be out on the street again. So those kinds of decisions are made.
So you mainly try to follow the same strategy you've so successfully used in the 70s in an adjacent field.
I think that the two fields are not comparable. In terms of, I said that I was born at the right time. The society was ready to draw on the talent of all of its people and not just some of them. It's not at the same stage now with respect to
questions about the death penalty are fairly easy, fairly European. Have you got? I don't mean they're easy in general, but they're easy to put as a European. I mean, have you got points of almost equal surprise or astonishment about European legal theory or practice?
I think it's wonderful. I once attended, Robert Badinter spoke in the United States, and he took great pride about how the death penalty was abolished in France on his watch as Minister of Justice. One could say, and he said the people never would have voted for it. Well, what about a democracy? I mean, what is the people's will? He was successful, and France never chose to go back the other way. But the question is, who decides? Does the executive decide? If the legislature decides, that's fine. Those are the people elected to make that kind of judgment. Do the people decide, as they did in California, the other way, to have a death penalty? The death penalty is the question of who decides is a very important one. And in some societies, it's easier for the executive to make that decision than it is in others.
Maybe it's a good moment to see what the people's questions are like.
My name is Tom Zwart. I'm from Utrecht University. You have briefly referred to the book called The Brethren and another behind-the-scenes book, the Lazarus book, about the Supreme Court. Undoubtedly, these behind-the-scenes books, attract an audience which is much wider than the legal community, and they inspire a lot of attention to the Supreme Court. But do you welcome such publicity? And if you don't, which I felt when you made your remark, which are the alternatives to meet the need for information among the people about the Supreme Court?
I think that all of us feel a need to have information, accurate information, conveyed to the public about the Supreme Court. My Chief Justice has now written 3 books. His first one was on the Supreme Court, how it worked then, in the days when he was a law clerk, how it works now, in the days when he's chief. I have written something that's been published in a law review about, that I call the workways of the Supreme Court. There are some very good biographies of individual justices that give you a glimpse of life on the court. I think what mainly turned up in the Brethren was that there was no smoking gun, that there was nothing really to report. The Lazarus book, all I can say is he's writing about a year when I wasn't on the court, but what he says about the relations among my colleagues is certainly nothing that I've experienced. Well, I'll give you just the kind of example of the greetings that I received from my colleagues. Justice White, whose seat I took, sent me a packet, and he said, don't open this till you're finished with your confirmation process, but when you do, maybe it will be a little help. It was his manual of chambers procedures that he and his law clerks kept up and improved every year. Well, that gave me a wonderful start to read through the whole thing and understand step by step how the court worked. Justice O'Connor, when I announced my first opinion for the court, the rumor is that the new justice gets a simple, unanimous decision. Well, my case wasn't simple. It was a really dense, sticky pension case. And it wasn't unanimous. It was 6-3. And Justice O'Connor was on the other side. As I read the summary of my opinion from the bench, she passed me a note and said, Ruth, this is your first opinion for the court. It's a fine opinion. I look forward to dozens more. That kind of spirit that prevails among all of us.
My name is Alton Heringa, and I do not work for Associated Press, so I hope my question reflects your very stimulating speech. I want to ask you a question about the beginning of your talk, namely how the Supreme Court chooses out of the 7,000 petitions the 100 cases to be decided. You said that not a criterion is basically whether an error has been committed by an inferior court.
Right.
Could you elaborate on that? Because for Europeans, the European Court of Human Rights, the German Constitutional Court, that's a bit of an odd way of thinking, not to pay attention to whether an error has been committed in the inferior court. And the second question relating to the process of choosing cases out of the 7,000 petitions is the rule of 4. Is it in practice really an important rule in the sense that in a lot of cases 4 justices decide on whether to take up a case, or is it more like a collegiate body that in a consensual process decides whether to take or not to take a case?
Why don't you begin with the second one?
All right. We confer every week or every 2 weeks. starting from the last week in September. Every petition received will be distributed to a law clerk pool to do a memorandum telling us what's going on in the petition. If ever I'm in doubt about a memo I get, I go back to the original papers and check myself. The chief then circulates a list of all the cases, say it's a 1-week interval and there are 300 cases on the list. He'll list all the cases that he thinks are worthy of discussion, not necessarily granting, but discussing. The rest of us then have 24 hours to add whatever cases we think we should discuss. So the moment the chief's list comes in, my law clerks then check my list to see if there's anything that he has not put on and ask me if I want to add it. So we will discuss only the cases that the chief or any of the other 8 of us put on the list. We discuss that at conference. We take votes. And if there are not 4 votes, the chief says denied. And if there are 4 votes, then it's a grant. Oh, error correction. Yes. I stressed that it's in large part luck that there are any particular 9 of us there at any particular time. We genuinely respect the views and think we are informed by decisions on hard questions made by other judges in the system. That's why we wait for what we call a deep split, so that we will have the benefit of the best thinking. And on hard questions, often a division of opinion before we jump in and take the case. Now, it could be from a lowly matter like the paper bag case. We have in our Constitution a provision that precludes unreasonable searches and seizures. And there was a time when the police were stopping, say, an automobile because they had a tip about the driver. And the question was what they could seize and inspect without getting a warrant. And the court had drawn something like a luggage line. They couldn't inspect the suitcase in the car. But if it was a plastic bag, they could. And then all these cases came up with distinctions. How about a naugahyde bag? How about one of those thick? Well, I wrote a decision in the D.C. Circuit. I was then a Court of Appeals judge, saying, I remember bringing to conference every kind of container that we had in the house. And I said, are we going to have our police make judgments? So the D.C. Circuit came out with the rule, no, the police can take all those items into custody, but they have to go to a judge to get a warrant before they can open them. The Supreme Court said the D.C. Circuit was right that we don't want our police to make these distinctions so they can open everything. But the one thing that this array of decisions that drew this luggage line showed was that was simply unworkable. That line was unworkable. We very often get excellent opinions on both sides. And the first thing that I look at is never the briefs that are filed by the parties, and not even the excellent bench memos from a law clerk, but I read the decisions on both sides of the issue that good judges in lower courts have written.
If I may add a brief question, you just mentioned that you wait for the deep split. You give opinions as a court in 1.4% of the cases put before you. What's the law for the other 98.4.6 cases?
Most of the law is made by the judge in the court of first instance because there's never any appeal. In a large number of those cases, it is a question of applying clear law to not so clear facts. So it really is a fact-finding exercise. The Court of Appeals, in many, many cases, they get it right. And if they get it right, there's no reason for us to intervene in most cases. So we try to settle what are the most divisive issues, like physician-assisted suicide, the entrance of women into Virginia Military Institute, like abortion. Think of the major controversies that the Supreme Court has settled because it had to. There was no one else in the system equipped to make the decision. Thank you for your patience.
The late and very much missed Supreme Court Justice Ruth Bader Ginsburg there, in conversation with the law journalist and university professor Mark Chauvin at the University of Amsterdam back in 1999. Did you know that you can go to our website, john-adams.nl/videos, where there's a link to the video of this extraordinary event? We also have a newsletter you can sign up for and a veritable treasure trove of great American thinkers and speakers at john-adams.nl. And while you're there, why not become a member of the John Adams? Not only will you support what we do, you get a discount to future live events. In the meantime, you should go to wherever you get your podcasts and leave a review of this show. This will help get the word out, and we can keep on sharing the very best of American thinkers in Europe with you, free of charge. That's it for this week's show. Our theme song is called La Prensa by the Parlandos. Our editor is Tracy Metz. From Amsterdam, this was Bright Minds, the podcast from the John Adams Institute. I'm Jonathan Goubert. Thank you for listening. The late and very much missed Supreme Court Justice Ruth Bader Ginsburg there, in conversation with the law journalist and university professor Mark Chauvin at the University of Amsterdam back in 1999.